Hey guys, Alex here with Wendy from Command the Courtroom. We had a little bit of a time zone issue, so I think I am 30 minutes early for my channel and 30 minutes late for Wendy's channel. And go ahead and introduce yourself to, I guess, both of our viewers.
Hey guys, it's Wendy with Command the Courtroom. Great to see you all. And Alex is such a genius when it comes to this co-live streaming stuff. Like, I have no clue how he figured it out, but it's really neat that we can be streaming to both our
At the
channels.
same time.
And at the same time, and I was looking at the Skype, Alex.
Uh-huh.
The last time we Skyped was 7 months ago. So I think that's the last time we did a live stream together.
Hmm.
It's been a little
It's
while.
been a while. Do you want to give the viewers updates as to why you can't take questions anymore, or do you want me? Go ahead.
Yeah.
You can talk about it. Yeah.
Yeah. So, and so I'm sure like a lot of my viewers have been wondering about questions. And, just because things with Command the Courtroom were getting so busy and I was getting a lot of emails from viewers asking individual questions, both in Arizona, out of state, and from across the world. And I thought I need to get an attorney involved with this because I just want to make sure that I'm not doing anything wrong. There's rules of professional conduct that I have to abide by as an attorney. And if I don't, then I put my license in danger. So what my attorney explained was by going on live streams and answering questions that I could be putting my license in jeopardy. And so I don't want to do that
It would be cool
because
if they sort of expanded the Ask a Lawyer program to somehow let lawyers like you, through that program on your own time separately, basically have the same protection of being enrolled in that program. I wonder
yeah.
what kind of additional things that they do, though. They probably have people register and provide their first and last name and stuff so that they can deal with the conflict issue. Whereas when we're just getting emails or questions on YouTube, it's tricky. And so yeah,
Yes.
there's the RPC angle, which is the rules of professional conduct, but there's also the disqualification angle where somebody could send Wendy like a question or something, and then they end up in court and they disqualify her and say, "Hey, she answered my questions on YouTube." And so
Exactly.
it's a business impact and an ethics. It's like a double whammy.
Totally, totally. And I've heard from several clients in the past that their ex or soon to be ex has gone around and has called different attorneys in the community just to disqualify certain attorneys
Hmm.
from taking on the spouse's case.
Hmm.
So people do this, and you're right. I wasn't really thinking of the business or the economic impact.
Hmm.
Just I don't want to get in trouble with the bar. I've never been in trouble with the bar. And 25 years in, I'm not ready to start. I just don't want to.
Yeah.
So, so what I've changed is I've gone over to an interview format and I'm still trying to provide as much helpful information as possible.
Hmm.
But, that's kind of where I am. But I'm still hoping that we can provide some helpful information here tonight, Alex.
Yeah. I was going to go first into how was your practice in 2020 with the coronavirus issue, both court access and, I guess, custody stuff that popped up connected to it.
Yeah. So, well, we're almost at exactly a year till it hit the fan. And I remember that because, it was right before my daughter's birthday, and it's again right before her birthday. And that's when things started shutting down. So right off, it was super scary for me because the courts were canceled for a couple of months. All of my court cases just were put on hold. I really didn't have much to do. Calls were quiet into the office because I think the whole world was freaking out, not understanding the coronavirus. So that kind of happened in the early part of 2021, or I would say from like March, April, May. And then things started to pick up again in June. I slowly started getting court appearances. All of my court appearances have been via video, and that might be something that we could talk about here tonight.
Hmm.
But every single court case, every single mediation has been on video. I haven't been to my actual office in almost a year now. And business is busy.
Hmm.
Getting a lot of cases now. I think, I don't know, you hear this stuff about families or spouses or partners being sick of each other,
Hmm.
and that's why it's falling apart. I'm super busy. In fact, I just hired a second attorney in my office. That's how busy I am.
Wow.
Yeah. So that's what's been going on in my office. But how about with you, Alex? I mean, I know you've been doing some interesting things with our Nevada
Hmm.
judges, and you recently licensed something. Maybe you can share with my
Yeah,
viewers
that was
what
pretty
happened
big.
there.
Definitely a
Yeah.
milestone. So the first milestone in 2020 was that we were on KTNV Channel 8. They used footage from our coverage of an unemployment issue that we were having in Nevada. So that was really exciting. And then the second milestone, which is much more exciting, is the A&E licensing a hearing video specifically for their court cam program. I guess it's a television and paid YouTube program. I've never seen a paid YouTube program before, but when I click the link to go onto their channel, it's got this, you have to like pay to get access to it. So I guess it's something that they have specifically partnered up with YouTube. But I suspect they didn't tell me when they were going to air it. They've already paid. They've paid quite a bit of money to license it, and it's a use license, so it's not like they own it. They're paying to use it, so I imagine they're going to use it as soon as they can. And if I was to guess, it would probably air on Wednesday. But that's something that I have no control over. I've given them permission to use one specific video anytime they want to. And I'm hoping that when the video airs, it'll trigger some traffic to the channel, which would be good because the channel definitely struggles more than the proper person. You would think it would be the other way around. You would think that
Yeah.
proper person would have less traffic than our Nevada judges, but that's just not the case. The proper person has 2 or 3 times as much traffic. The only time it's ever really competed is when there's a trial we were covering, of which we've only covered one. So, well, it was
Okay.
two technically, the same person, but they split it into two. That's all the stuff that's going on my end. And then with the day job, Amazon's been fine. The coronavirus didn't impact Amazon adversely at all. I don't think it.
Not at
Yeah,
all.
it
I
kind of like
Not at all.
my stocks shot up, so that
I
was good. Yeah,
bet.
they give us stock when they hire employees at Amazon. Everyone gets stock. It's a different number depending on your position, but as far as I know, we all get something. But so everything's been good for me, and it sounds like for
Yeah.
you as well. So
Yeah. It's been super good. So, yeah. So that's interesting that, the Nevada judges website struggles a little more, but like with the licensing thing, who knows what that could lead to
mhm,
in the future. I mean,
exactly.
that's really awesome. So what's going on in the custody world, Alex? I mean, I know that you're the appeals guy. I don't know if there are new cases or,
Yeah,
um, uh, either public figures or new Nevada cases or anything like that that you want to share that
actually,
we
yeah.
should talk
That's a
about.
good
You
question.
know?
That's a good question. I didn't even think of that, but I already have 2 or 3 thoughts that popped up. I guess the
Okay.
quickest would be there's a Senate bill that's been proposed that's going to have child support for parents with joint custody in Nevada. So I don't know
Oh,
if you've heard about that, but
I have not.
yeah. So we already offset child support. So if mom makes 1,000 and dad makes 500, 1,000 minus 500 equals 500, and that's what's used to compute the child support. But they're going to do the same exact thing, same exact formula, and then they're going to add on to the end of it all divided by two. So it's
Mhm.
going to severely soften child support in joint custody situations. We had a really
Oh,
big publication. It might not have been published. It might have been in bank unpublished, which would be a travesty. I would like a case like that to publish. But it was a huge disqualification case that came down in Nevada. A family court judge, he just made a number of remarks throughout all of the non evidentiary hearings about the case. There was just a bunch of interlocutory hearings, status checks, and stuff that popped up. And the parent used that to disqualify him. And the chief judge
oh,
originally refused to disqualify him, and the Court of Appeals intervened and issued a writ of mandamus commanding her to change that. What was interesting is this is something, in my opinion, that kind of happens all the time in family court. Judges will signal what they kind of want to do. There's not really that many trials, and there's not that many evidentiary hearings. A lot of things get sorted out during these other hearings, these review checks, these case management conferences and stuff. And the Court of Appeals expressed some concerns. Basically, they indicated that a judge shouldn't be making comments on a case when they haven't taken evidence yet. And that's, I think,
that's interesting.
something that's sent shockwaves through the family division in Nevada, because this is just something that they all typically do. I with my our Nevada judges work, I've noticed that the other judges don't do this. They just don't do this. The non-family division judges, they're doing criminal cases, civil cases. They have their own way of handling their cases. Whereas the family court, this is just kind of a normal practice to tell you, I don't know what I think about this, or they'll just sometimes just make a summary ruling. And so anyway, I published a video on that, and it got a lot of activity because a lot of people want to disqualify their judge in family court cases, thinking that the disqualification of their judge is going to suddenly fix everything. Which, I mean, I can go into a little bit more, but tell me, does that something
Yeah.
that you go through as well with your clients?
Well, you know what? We do deal with that quite a bit
Yeah.
in the family court system here. And, I think there are some judges who lean more heavily on the parties than others to settle,
Hmm.
and they tell them that, the presumption is that, joint decision making is in the best interest of the children, and that frequent, meaningful, and continuous contact with both parents is in the best interest of the children. And that's pretty much what I'm going to go with, unless you can give me a really compelling reason. There's a handful of judges who do that, and really, I don't know if you want to call it guilt. It could be guilt or pressure
Hmm.
the parties into
Hmm.
settling, or scare them.
It
Uh,
does.
and then there's other judges who I think, and maybe it's the way that they deliver it.
Hmm.
It's more of an educational thing.
Hmm.
They're informing the people, like, this is what the law says,
Hmm.
and you have to know that I'm going to follow the law.
Hmm.
But I have had my share of clients feel strong-armed, into settling cases when they didn't really want to.
Hmm.
And I'm wondering if judges, I don't know, I haven't practiced in other areas of law for a while, and the only other area I practiced in was criminal. Um, but I'm wondering if judges are more apt to do this in the family law forum,
Hmm.
because a lot of people are pro pers,
Yeah.
and they just feel like, you know, pro pers need to be educated.
Hmm.
Or I don't know. What are your thoughts on that?
I think it's two things. I think the non-family division judges aren't used to as much discretion, and so they kind of fit more into the role of a referee. It's like the legal framework seems to lean more into you're here to interpret and apply existing law, whereas the family judges have so much discretion that they can sometimes. I don't think that it's like overt, like they wake up with like evil intent. I just think that after years and years of it, they kind of become a law unto themselves because they can kind of do for the most part whatever they want with a few exceptions. And so that's kind of I think it's more of a subconscious slow sort of gradual move in the direction that they've gone, and that's kind of where they are now. I do think that a little bit of it is educational, but I think when you give somebody that much latitude to make rulings, I don't think that they see the harm in it. I don't think that they see the point. And maybe they've seen a lot of cases where people thought they had a case and there was nothing there and they felt like their time was wasted. Maybe they've seen that 1,000 times and they're sick of it.
Yeah.
Maybe they're sick of trials and evidentiary hearings, not because they don't want to do their job, but because they have seen too many occasions where it was a waste of time. Um,
Yeah.
and I mean that I think that's a big part of it there. And you're right that with non-attorneys, with self-represented people, they don't know the law, and so they might think that things are going to go a certain way, and the judge might be like, "Oh, if only they both had lawyers," because then their lawyers would tell them this is going to
Yeah.
be how it's going to be, and this wouldn't be an issue for me to have to sit and preside over. They have a lot of
Yeah.
work here in Nevada, thousands of cases per year, so they're stressed out. I don't know how they are in Arizona with their caseload,
Totally.
but yeah.
Same.
And so that could
Each
be part of it
judge,
too.
yeah, yeah, I agree. I mean, I think each judge has a docket that's probably a couple thousand
Hmm.
cases. So, that's stressful. They're stretched thin, and, they're getting bombarded with motions and hearings. So, that's probably part of it too.
Yeah.
But, I think the thing that you and I both try to encourage of people is to educate yourself. It's important. People have to know the law in their jurisdiction, and then try to do their best to apply the set of facts in their case to the law and see how it measures up,
Hmm.
because you have to do a reasonableness check. Otherwise, you could be putting yourself on the hook for attorney's fees if there's an attorney on the other side and you're not being reasonable in view of the law.
Hmm.
How would you share with people how to evaluate whether their position is a reasonable one or not, Alex?
Well,
How can
the first
how can people figure out whether they are moving forward in good faith? Sorry about that.
sometimes with some people it's so hard. I mean, the first thing that I try to tell my viewers is you can feel as strongly as you want about an issue. The judge is going to enter an order, and you're going to be forced to do it. So you have to really try and figure out what it is that the judge is going to want to do, which is directly connected to what's the law. And so sometimes people are like, the two biggest ones are deserving custody and custody by morality. So with custody by morality, the hang up is was cheated on and they're an evil person for cheating on me. And they just don't understand that the courts, for the most part, don't care when it comes to best interest of the child. And then I guess there's there's like maybe 2 or 3 states that do care, but it's rare. And then the second one is deserving custody, which is the person has had the kids with them all the time. They were a stay-at-home parent. The other person went to work, and so they feel like they deserve custody because they had the kids all the time already. Those are just 2 of the more common things that get people stuck, and they want to go to war over those issues because they can prove it all. And it's like, well, in Nevada, they don't care. They want to know what's best for the child going forward. I mean, it's nice that you did all those things. You kind of deserve a badge for that, but that's just going to get you back into best interest of the parents. So sometimes I'll direct them to those 2 videos, and then I'll direct them to best interest of the parents, which is where people may not mean to do it, but they get stuck thinking about what's best for themselves and the other parent, and sometimes the child takes the back seat. A lot of the stuff is subconscious. So to get the person to get access to those thoughts, you have to really get them thinking. And when people get so invested in this idea of a specific outcome, it's hard. It's hard for them. So
I agree, and that's one of the best interest factors in Arizona is what the future relationship of the parent, each parent and the children could look like.
Mm-hmm.
And even though one of the parents, like say a dad, was out, traveling for work and rarely home during the relationship or during the marriage, in my experience, if this person is saying, well, I'm changing my habits, I'm changing my work schedule, I've cleared it with my boss, and I have to be different now that we're splitting up, usually a judge is going to give them that opportunity, regardless of what the history is. That is my experience. And, that's often a hard pill, like you were saying, for someone to swallow when that wasn't the case during the relationship. But, the judge will give them the chance. And then if it doesn't prove to be true, then, the parent has the opportunity to go back to court and say, hey, like I've kept track of all the parenting time since the decree was entered. And it's the same as it was. And the kids are never with him. They're always with a third party care provider, or they're with me. And, he's getting a child support benefit. So, I think judges are going to look at what does the future have the potential to hold more than what did the past look like.
Yeah.
So I would agree with you on that. Totally.
And when you think about it, if you give somebody a theoretical, like if both of the parents have joint custody and the child is with both of them and the child for sure benefits from that, it's sad that you don't feel it's fair, but fairness is different from best interest of the child. It's just like, it's just so hard. And especially, I feel like with younger parents, especially because your child is still really teeny tiny, and it's just hard to get it into your head that you're going to not see the child for so much time. And so I don't know if you have this issue, but sometimes it's like, just to avoid a terrible outcome, they'll almost see things that aren't really that big of a deal, or sometimes they'll just see things that aren't true just because they need those particular things to be true to get the outcome that they want, which is that the child stays with the most of. So I don't know if you have that additional problem or not.
Sometimes, I do. The thing that I hear a lot from various parents is that, and it may be true in some circumstances, but what I hear a lot is that after the child or children come home from mom or dad's house, that they act XYZ, crazy. And I hear that so much, which makes me think that judges hear it all the time, probably every single day. And I feel like they're probably kind of immune to hearing that. And what I often hear judges say in response is, well, children are resilient and they're going through a transition too, and this is not easy. And of course they're going to act out. But I do hear that often, as something that a parent cites to as a reason for the other parent not, as a reason for arguing that the other parent should not have joint decision making or equal time.
Yeah. There's a curiosity here. It's not really a legal advice question, but is it true that relationships between attorneys and judges have an impact in cases? Sort of a general question.
Yeah, I think to a certain extent that they do. And I would say not in a nefarious sort of way, but as an example, a lot of people who are becoming judges now I used to practice with. We
Mm-hmm.
started out as young attorneys. And so they know me, I know them.
Mm-hmm.
And if I go into their courtroom, if we're not close enough for them to need to recuse themselves, they know Wendy is a sharp, a straight shooter.
Mm-hmm.
She doesn't mess around, she doesn't lie. And so I think they, I have a certain level of credibility with certain judges. So to that extent, the relationships do matter.
Mm-hmm.
If a judge knows me as somebody who is slimy or a liar or not
Mm-hmm.
prepared, I think that's certainly something that they would consider if I set foot in their courtroom. So I do think that those relationships matter. And
Mm-hmm.
sometimes as an attorney, I'm a complete unknown to a judge. There are a lot of judges on the family court bench that I don't know. I don't know them anymore because they're new, and a lot of them are younger than I am. And
Mm-hmm.
so, I think that when I'm in front of those judges and they get to know me and see what I do in the courtroom, then maybe that lends some credibility after I've
Mm-hmm.
been in front of them a couple times. But yeah, I think those relationships do matter, but I don't think that they matter in the way that a judge is going to do me a favor.
Mm-hmm.
Just because a judge might think I'm a straight shooter doesn't mean that I go into their courtroom and they do what I want. I
Yeah.
don't believe that at all. But I believe that they trust that I'm not going to go in there and lie or present a client who's lying and do it knowingly. So
Yeah.
does that make sense?
I think it does, and I think it's just the reality of being human. I know that. I mean, I have always advocated for getting as close to equality, between proper person and non-proper person litigants. But as close to equality as possible is never going to actually be equality. There's always going to be a relationship between attorneys who went to school together and who work together, and you can't completely eliminate it. You can do your best and try to compete with it, but for me, self-representation is never really the objective. It's the last resort. It's the thing people do because they can't afford it. It's not the thing people do because it's better. And that's what it always was for me when I represented myself for 8 years. It was just not enough money. It's either that or don't do anything. And so,
Yeah.
I was curious when you mentioned your 2020 remote hearings. Were any of them trials?
Yes, a
Oh,
bunch.
the,
I had a ton of trials. In fact, in the last 2 months, I've had three major video trials. And yeah, they're crazy. They're wild. I mean, luckily, I feel like I had a little leg up because I kind of know this video YouTube stuff,
mm-hmm,
Zoom stuff.
mm-hmm,
But it adds a layer of complexity
mm-hmm,
because I haven't been in the same room with my clients, so usually I can just lean over and whisper into their ear about, is that true or whatever? And I can't do that now. We've figured out how to navigate around it. So with my clients, we'll either get connected on Messenger or on Skype, and that way we can communicate when the other person or their witnesses are
mm-hmm,
testifying. But that's a layer of complexity because I'm not in the same room with them. And then with the exhibits, it's difficult, I think, for clients sometimes because usually, well, they have to print out their own exhibits and organize them and have them ready. Not just the exhibits we're presenting, but the
mm-hmm,
exhibits the other party is or is
mm-hmm,
presenting. So that's, an added layer. And if I had my act a little more together, we could get it all bookmarked and stuff
mm-hmm.
on Adobe, but we haven't been able to do that. Usually the copies of exhibits are hard. We upload our exhibits to the judges in advance and they can view them
That's
electronically.
good.
I think it has brought the courts, into the world of technology finally, because there are so many types of hearings that I would traipse down to court and spend $700, $800, $900 of my client's time for a 10-minute hearing,
Mm-hmm.
between travel to and from court and all of that. And now, it's like a 10-minute hearing, and that's how much my clients get charged for, and that's the way it should
Yes, it
be.
should. I've
Uh,
yeah.
yeah, but the trials have been a little bit of a challenge, but we're doing them. We're doing them, and I've had several clients who've had victories, and so it's possible to navigate it.
Mm-hmm.
You have to have redundancy. That's what I tell people. This summer we had some work done outside our house, and internet got cut.
Mm-hmm.
So you have to have that backup, even if it's just a phone
Mm-hmm.
or an iPad. Don't have drinks and food, and eat on camera. My ethics lawyer did a presentation to my office the other day, and she said that there was talk in my county, Maricopa County, among the judges that there was actually an attorney who was conducting hearings from the swimming pool. And she's like, don't do it. So, you still have to be appropriate, dress appropriately, speak appropriately, and just be respectful. But it's been fun. It's been interesting.
Have you had any issues, not necessarily even an overt allegation, but suspicions that with the remote trials, maybe the witnesses are being like coached a little bit? Because that's come up over here.
Yeah, well, I had it happen during
Uh-oh.
one of my first hearings. I'm just saying hi to Dwayne. He was on here a minute ago, DSD, Dead
Mm-hmm.
Surviving Divorce.
Mm-hmm.
But actually, so in one of the first hearings that I had, an attorney was in the same room with her client. And I asked the client a question, and we saw the attorney whisper something to the client, and the judge caught it. And so the judge had a cow, of course, and said, "You are not allowed to do that. Do not do that anymore." So, I mean, that was right on camera.
Wow.
But, from my perspective, I feel like it would be pretty
Mm-hmm.
difficult to coach a client as they're testifying. But that's because I'm so present on what I'm asking and what they're saying.
Mm-hmm.
I have a hard time dividing my attention, but I suspect that there's some people who can multitask really well, that maybe they're doing that.
Yeah, and I feel like you're above board. I mean, you know that that's not even what you're supposed to do. So it probably didn't even cross your mind to do that. You have the job. You're the
Yeah.
lawyer, and the client's testifying. And I've like in my case, there were a number of times when my ex's attorney tried to speak for her, and because I was unrepresented, the judge just was kind of winging it and just let her do that. And it's not good because the evidentiary hearing is the one chance that the court could examine the actual parent. It's the one time. And so take
Yes.
advantage of your one opportunity to make some findings of fact based on the actual person. But I mean, there were numerous hearings published to the series, to the My Docket series, where that this didn't happen. My viewers bring it up a lot because they go through it too. So I wonder if that's even without coronavirus, if that's an issue that comes up a lot in child custody cases.
I don't know. And I see a lot of attorneys leading their clients during direct examination. And so what I was taught um, is that direct examination is your client's opportunity to tell their side of the story and to let their credibility shine,
Mm-hmm.
for lack of a better phrase, right?
Mm-hmm.
And so you should be letting them do the talking and telling the story, not you.
Right.
And so then, what I was also taught is that cross-examination
Mm-hmm.
is not only an opportunity to reveal inconsistencies in the other parties or witnesses, statements, but it's also an opportunity to again tell your story. So during
Mm-hmm.
cross-examination, you are leading, you're doing nothing but leading,
Mm-hmm.
and you're telling the story that you want to tell.
Mm-hmm.
So I think it's odd when I see an attorney leading their client during direct, because I feel like, yeah, they're not letting the judge see who that person is.
Right.
And that's what the judge needs to make a decision on, which
Right.
was just what you were saying,
Yeah,
Alex.
I think that a lot of there's a lot of things that judges, at least here, complain about not having enough information, and these decisions are terrifying with the information they have. And it's like, well, you have opportunities. I just don't know if they really push for that. From what I've seen, there's a lot of videos published to YouTube. It doesn't seem like they care. But you're absolutely 100% correct. I agree. That's how you're going to find out the little information that you can is during cross and direct examination. You have a compliment here I was going to read. It says, "Thank you, Alex
Oh,
and Wendy. Your guys' stuff really helped me so much. I'm just a guy that
yay.
tries real hard, and a few years ago I got full custody." And he basically gives credit to
Yay.
our channels.
That's so awesome. I love hearing those stories. And you guys, please share those stories. And just because I can't, answer your questions directly unless you're in Arizona, then set up a consult. But it doesn't mean I don't love you all, and I see you, every week. Tenacious Warrior, Raul, the
Hmm.
people who show up. Brandon Cam shows up every week. And the fact that we're making a difference in people's lives means the world to
Hmm.
me. And that's why I keep going with this stuff.
Hmm.
So I love it. That's cool.
One thing that I wanted to mention when you were talking about the tallying of the timeshare schedule to modify custody because the child was with a third party caregiver, we have some precedent here that says the opposite. That apparently, if you are a parent and you leave your child with a responsible third party caregiver, the court can't modify custody. Is that a shock to you? It's a
Yes,
shock to a lot of people here.
that is kind of surprising to me. I mean, is there any kind of I mean, are they talking about, does it matter how much time that the child is being left with the third party caregiver, or is there's some kind of threshold? Because what if the kid's being left with a third party like 75% of the time?
Apparently, as long as it's a responsible caregiver. I guess what the Supreme Court was concerned about was going back to, well, this person works and this person doesn't, so give that person full custody. But maybe, I mean, maybe there's more to it than that. Maybe they consider leaving the child with a family member as an important thing that's good for the child. Maybe it would be different if they left him with like a sitter at a daycare or something. I don't know. I haven't looked at the case in a long time, but it has come up. It's caused a couple of reversals so far. At least one or two, not many, but just, you know.
That's interesting. You know, I heard of this case recently where I guess that, see, the kid lived, let me see if I can get this right, lived in Arizona. And then one of the parents took the kid for a visit in another state. It was like, let's call it Nevada, and just kept the kid and hasn't returned the kid back to the parents in Arizona. And so now, though, the parent who's in Nevada with the kid has been very ill for months and in and out of the hospital. So the kid is staying with a grandmother most of the time. And the parents are arguing about where should the kid be. And I guess my inclination when I heard about this was, well, the kid should be with a parent. If one parent cannot be with the child at all because that parent is sick and hospitalized, and the kid should be with the other parent. But the case that you just brought up might suggest something different. What are your thoughts on that? Or do you think it's a little bit different?
Well, you know, part of my belief is that it should be a best interest of the child, third party caregiver. I mean, I think that there is some kind of benefit from a relationship with an aunt or uncle or grandparent. And so that may be deliberate even. There may be a parent who deliberately is like, I want my child to spend 2 weeks in summer with this person because they can teach them hiking and stuff. I feel like for something like that, it's just the extension of the parents' rights. I agree. But then there's other odd situations where I might not so much agree. Like if you're just leaving the child at a daycare, maybe the situation's not the same there. And oftentimes judges here are encouraged to just alter the schedule. So if a person's working full time and they're not seeing their kid that much, maybe the visitation schedule just needs to be adjusted. So maybe you have a stay-at-home parent and a person who works full-time. Maybe the court should make sure that those days off go to specifically that parent. They'd be more inclined to do that. I feel like an issue would arise more if the parent was working like 80 hours a week or something. Something like that might be more of a problem. I haven't looked into it very carefully. I feel like off the top of my head, it's the Rivero case, which is one of the huger cases here. But unless I go back and check, the only glimpses I see is when these orders reversing come down and I add them to the Nevada Judges website.
Oh, I got it. Well, I mean, the thing is about these cases, like, okay, so we should talk about a case in a minute that's crazy. I think it's crazy. But the thing is about cases, you guys, you have to remember, and probably nobody knows this more than Alex, is that just because a case says something doesn't mean that there isn't wiggle room there. And, you know, one of the things that I was taught from my very first law professor who scared the hell out of me, and he wrote the anti-racketeering statute, his name Professor Blakey, but he said, listen, if you cannot distinguish your case from a case that's written in the statute books or in the case books, then you're not being creative enough. This boils down to being creative, and you have to think outside the box. So I just want people to remember that despite whatever the Rivero case says, doesn't mean that is set in stone forever. Like maybe your case, you know, could be the exception. You just have to be brave enough to argue that. What are your thoughts there?
You're right. Case in point, Rivero there was a rehearing on it and it changed itself. So there's Rivero 2008 and then they granted a petition for rehearing and replaced it with Rivero 2009. Then it branched out with Bluestein. So there's a case that attacks the 40% threshold. there's all kinds of branches coming out of that case. So you're right.
Yeah. Yeah.
There's distinguishable from the instant case and analogous with so there's these arguments that your case, one side's going to say it's analogous, it controls, the other side's going to say it's distinguishable, it doesn't control. And then you got stare decisis arguments. So well, let's just change the law because
Yeah.
so there's a lot that you can do. It's exciting to talk about this stuff. And then I mean, I don't know what else to. I mean, we can get really technical, but there's a lot of stuff out there. Shepherding is a thing that I've never done that I should have learned but
Oh
never did.
God. Do you want to tell people what shepherding means?
Well, my understanding, and you should correct me because I've never done it before, and the reason why is because they could never afford Westlaw. So
Yeah.
shepherding. So I just use Google Scholar, which doesn't have any of that stuff. So shepherding
Yeah.
is this. I think it's this thing that this technique that you go about checking to see if portions of a case have been disapproved of or abrogated or changed or replaced. I
Right.
mean, I'll let you give the final answer.
Yeah, yeah, that's correct. Well, so, I will start off with a disclaimer and say that legal research was not my forte in law school. And when I was in law school, Westlaw was just coming out, but mostly we had to just learn by going to the books, the hard books. But shepherdizing, that's what we called it.
Mm-hmm.
And that is where now I think it's pretty easy. If you do have a Westlaw subscription, you check to make sure, like you said, the cases haven't been overturned or reversed,
Mm-hmm.
or, parts of them haven't been taken back, for lack of a better word. And it's important to do that, for people who are relying on cases, because there's probably nothing worse than citing to a case and then finding out when you're in the middle of an argument, right,
So
that
bad.
it's been remanded or abrogated or something like that. That is bad.
There's a
So shepherdizing, you guys, check it out if you're doing your own research.
The worst part is when you cite a case that's not effective and you win for other reasons, so you don't even know, and you find out years later, you're like, I won because I used that case, and years later you found out, no, you didn't. That case was wrong. You won for other reasons, and the judge didn't tell you. There was a
Yeah.
case that I used, a Wadley right here, that says you can object to your judge presiding over your own contempt hearing. You could get another judge. And I was so proud of myself because I used the case and my judge took back the whole contempt, and I thought I figured out the law, and I found out there's an exception to family court. So it didn't even apply. He just canceled his own contempt hearing for other reasons and he didn't tell me. So
Oh my.
sometimes you'll use the wrong case and not even know, and it's just planted in your mind waiting to go off later on. You're giving bad people advice. You're telling people this is a great thing you could use. It doesn't really work. So
Yeah.
you really have to know what you're doing.
Well, you know what? And to that point, I have to say, almost every case that I go into trial, I think, man, like these facts, like this situation or this thing that happened here,
Hmm.
this is going to win the case for us. Like this is what's going to do it for the judge. The judge is going to rely on this,
Hmm.
And even in those cases where I get a great result, it's rare that I predict that with any kind of accuracy.
Hmm.
And usually the judge comes like latches on to something like out of the blue. I have no idea. And I'm like, what? So I
Yeah.
just, I should stop trying to predict what judges are going to do, because I'm not a mind reader. I'm not a fortune
Hmm.
teller. I'm intuitive, but I can't figure it out. And I think like judges
Uh-oh.
are different, and that's what I tell people. We may have a great judge, but are we
You're
still there?
back. I lost you for about a
But
second and a half, but
okay.
you're back now. You're back. Keep going.
Okay. Even with great judges, sometimes they have bad days and sometimes they make bad decisions. I've
Uh-huh.
had it happen, seen it happen. So that's the scary part about going to trial.
Yeah.
You never know what's going to happen. But we did have an interesting spousal maintenance case come out of Arizona I think it was early 2020. And I'm sorry, not spousal maintenance, an annulment case.
Hmm.
And actually, so the case that brought this case to my attention, was a case where parties got married in Nevada after a long night of drinking. And one of the parties was actually married prior to this marriage taking place. And then so now the parties want to annul the marriage. And they were married for quite some time. Well, there's a new Arizona case that says even if a marriage should be annulled,
Mhm.
anything that was accumulated during the quote marriage should be divided equitably.
Mm-hmm.
So even though the marriage was void ab initio
Mm-hmm.
in this situation, it wasn't a valid marriage because one of the parties was married. The parties are still going to have to divide whatever was accumulated during their marriage
Mm-hmm.
equitably. And it just like boggles my mind. I can't wrap my head around it, but that's what the case
Maybe
says.
they used equitable estoppel because in Nevada we have a case. It's older though; it's not recent, and the Supreme Court used equitable estoppel to block the other person from using the argument that this marriage wasn't real. But for it to apply, they had to go through these elements to satisfy equitable estoppel. And apparently, what happened is the husband lied. So they got married, and then the husband threw away the certificate, and he didn't tell the wife. And so they just went along acting like they were married the whole time, and he just didn't send in the thing to I guess the county recorder. And so the Supreme Court of Nevada published and said, yeah, this wasn't a marriage, but equitable estoppel takes into consideration the deceit, the fact that they both thought they were, or that they were acting married, that the victim thought she was really married, and they said for all these reasons you can get this. There's nothing to annul. There's no marriage there, but you can't use the argument against her to block alimony and division of assets and debts and all that stuff because of the deceit.
Interesting.
That may be something similar. If you use the word equitable and you poke around there, you might see equitable estoppel or something like that. Something like that must have
Uh,
been going on. Maybe there was some deceit or trickery. I feel like if the other person knows, then I mean, what are you gonna do? There's you're not married. You just faked it.
yeah,
But when the
yeah,
wife was in this case tricked, it's different.
yeah. That's
It's just a
interesting. So
hunch.
do you want to explain to everybody what equitable estoppel means?
So my understanding is that it blocks you from using certain legal principles if you have gone about it in an unfair way. And there's these three or four different elements that have to be satisfied for it to work. I talked to my viewers about judicial estoppel and this collateral estoppel, which I know a lot more about. This is one of the ones that I've heard the term and I barely read a case on it. I wish I knew more about it. But just like with any estoppel, if you satisfy all the elements, then it effectively blocks the other party from using that particular whatever they're trying to assert. And since it's a legal mechanism, you get de novo review on appeal, which is I'm always looking for those swords. De
Oh my
novo
God,
review
Alex.
is where you can win appeals, and
Oh,
always looking for
geez.
those. Use them anytime, any chance you can. People come to the channel and they're like, I want to, argue in court that they didn't, that we already had a hearing and this was discussed. So I was like, you're talking about some res judicata principles. Look into that. Why? Because it's illegal. And it ordinarily, when you go into court for your first trial, there's not a whole lot you can do. There's going to be a bunch of findings of fact made. The judge is going to get a tremendous amount of deference. You're probably going to be screwed. But later on, when you come back and you have some res judicata arguments floating around, some change of circumstance arguments, now you actually have something you might be able to appeal on because you're going to get de novo review on that stuff because those are legal arguments. So people don't know the
So,
distinction.
yeah, okay. So I want to talk about that change in circumstances and and those um I had a case dismissed this year because a judge said there wasn't a change in circumstances from the time that the parties went through their original custody proceeding.
Mm-hmm.
And what the judge said to one of the parties was, or, to my client, was that you raised these same issues at the time of the original proceeding. So there's nothing new here, and goodbye. But the thing is, although the client raised these things, I feel like what was happening was new and more extreme than what had happened originally.
Yeah.
So to me, that felt like a
That's a change. In
change.
Nevada, a case published called Castle v. Sims, where they talk about that, where they say
Yeah.
there's two things. Number one, the same things that were brought up get worse. And number two is you learn that the extent of what was going on. So maybe it's the same as it was now, but you didn't at the time know the extent of it. And so Castle v. Sims, it mainly, I think it's purely a domestic violence issue. And the court was
Oh.
like, we're not going to revisit this. We've already discussed domestic violence. And the Supreme
Oh.
Court said, well, hold on a second. What if it's worse? What if it's worse than they thought? Or what if it's still going on and it hasn't stopped yet? That's still a change of circumstances because you would assume that when you addressed the issue and you made a ruling, it wouldn't keep happening. So
Right.
they talk about that. They don't like when res judicata principles just get conflated with the judge's own personal idea of what he thinks it is. They actually apply the real
Ah,
principles. That's the beauty of de novo review. They'll supplant the judge's thought process with their own. They'll just completely
interesting.
discard it. So
Interesting.
that's
Well, what about a situation, Alex, then? So say, like in the example you were just giving, a judge in the original proceeding said, well, I find that there was no domestic violence. I find that, you know, the alleged victim is not credible. Yet, 2, 3, 4 years down the road, the alleged victim is bringing more stuff up because there's been stalking charges or orders of protection. You know, what are your thoughts on that? I mean,
so.
is that is that new then?
This is what's. I'm gonna get really technical, but my understanding of the change of circumstances idea, at least in Nevada, is it comes from a statute here. If it wasn't for the statute, it wouldn't even exist in Nevada. And apparently, it comes. I don't know if you know, there's two species of res judicata. There's claim preclusion and issue preclusion. The old terms were merger and bar for claim preclusion and collateral estoppel for issue. And they were completely different. So apparently, the statute in Nevada that talks about change of circumstances only applies to primary custody cases. And why? Because the statute says so. If it said otherwise, it would apply otherwise. If it didn't exist, it wouldn't even be there. So apparently, that is the prong of res judicata that deals with claims that have been brought and addressed and claims that could have been brought and addressed, but just for whatever reason weren't. And then the other one, which is the issue preclusion, that's the one that deals with specific issues that went to an actual evidentiary hearing and were ruled upon, and there's a finding of fact that was entered by the judge. And the way those two things work is completely different. So, I mean, I don't know if that helps. You're talking about new things coming up. In my opinion, I would argue. So when my ex's attorney would say change of circumstances you can't use is, I would bring out those terms. I would say she's talking generally about change of circumstances in family court. This doesn't apply because issue preclusion applies and these elements have to be satisfied and these are new things that came up and the judge hasn't made findings on any of these new things, so that doesn't control. It's
Wow.
crazy technical. I feel bad even. I mean, to get my, it confuses the judges all the time. It confuses them all the time. It's there's a case here, McGonigal that the judges cite in error all the time, and there's a case that corrects that, and that's called Ellis v. Carucci, which is the case that splits analysis on a motion to modify custody into two prongs. First is there a change of circumstances, and second is best interest of the child. But still, it doesn't grapple with what res judicata is. In fact, the only cases that grapple with those are non-family court cases. So unless the judge digs into what those things are, the judge is going to make a mistake. And it's complicated when you hear it, but when you think about why, then it makes sense. Like, for example, say somebody brought up a bunch of issues, but it never went to an evidentiary hearing.
Right.
Hold on a
Right.
second. What if something happens later? What are you going to use to test whether that can come up? And that's where you look at the issue of the change of circumstances statute, which says it has to be something that's happened after this date. And that's the whole claim preclusion creature. And then you've got other situations where, like, that doesn't make sense because the judge specifically talked about this and specifically made this finding. And so even though we're joint physical custodians and the change of circumstances doesn't apply to us because it's not in the statute, this doesn't make any sense. Well, guess what? You're right. You're talking about issue preclusion and you just don't even know it. You just don't know there's a label for what you're talking about. I think a lot of times attorneys and non-attorneys talk about stuff that's not fair and they don't realize there is something there. They just don't know what the name of it is.
That's
It's
interesting.
very
That's really
interesting. And
good.
those arguments are legal arguments which will trigger reversals on
Yeah.
appeal. So to
Oh,
family court judges, it sometimes catches them off guard because they don't know the little teeny tiny nuts and bolts of what they're talking about. They just sort of know the abstract overarching idea, and then a really
right.
savvy attorney knows, files an appeal, gets it reversed, and they're like, what just happened to me? So
Wow. So, yeah, I'm gonna have to do some closer looking at res judicata. So when you were talking, Alex, you brought something up that I think is worth mentioning here, and on change in circumstances. So, and I've seen and had cases dismissed because a judge says there's not been a change in circumstances. because you brought this up in the past hearing or in the
Mm-hmm,
past.
mm-hmm.
Yet, clearly, what is happening right now is not in the best interest of the children. So you were just talking about a case where there was another prong created or there was a
LSV
distinction.
Carucci. So
Okay, so
that's a
talk about
big
that.
deal, and that I think helps a lot of family court judges. But still, they're still going to mess up if they don't know why it's going on. LSV Carucci explains that the change of circumstances analysis is separate from the best interest of the child analysis. And they
Mm,
explain that the change of circumstances question is a threshold question, and that once you cross that threshold, then you go into the next step, and the next step, which is best interest of the child, you can look at everything. So in LSV Carucci, they explain that if you can show that a change of circumstances has occurred, then you move on from it. All of the things from the past can be brought up at a trial because now we're looking at the history of the case, what happened to the child. It's like saying they punched the child and the court made a ruling, and now they punched the child again, and now you can't consider the fact that they punched him before. Like, that's dumb. Obviously, there's a change of circumstances because there's more physical abuse now, and you have the pattern from the past. And so LSV
exactly.
Carucci says that yes, you have to consider that once they cross the threshold question of has there been a change of circumstances. And again, that's still confusing in a way because guess what? It only applies in primary physical custody situations because the legislature said so. And I think that non-family attorneys get it because normal lawsuits have the same course. Civil lawsuit, you sue for money, you win your case, it's over. Claim preclusion triggers and blocks you bringing any claims that were not addressed because you should have brought them up. So for normal lawsuits, claim preclusion is just a natural thing. Whereas in child custody in Nevada, our modifications for to child custody happen post-judgment. The same case is open. It never you reopen the same case. So the only way that they can get claim preclusion to apply is to create a statute that says so. And this is a big giant mess in my opinion, and it just confuses a bunch of people. I hope I didn't go too far with it.
No, no, no. This is really interesting stuff. And so as you were talking, you made me think of something else, which I think bears worth mentioning here, and that is, so I've had a couple of cases lately, and I don't know if this is the situation for Nevada. I'm interested to hear, but the other party is very upset because I'm bringing up domestic violence that has happened like decades
Mm-hmm.
ago or a decade ago. And they're saying that's not relevant. That happened so long ago. But in Arizona, the statute for decision making and parenting time considers whether there was either or has been a significant history of domestic violence or whether the domestic violence has been significant. So in my mind, the fact that something happened, 25 years ago or 30 years ago is absolutely relevant
Mm-hmm.
if there is domestic violence, that is continuing into today. But do you know what Nevada's statute is as to,
Yeah.
history of, yeah, what is
So
it?
it doesn't discuss the history, it just flat disqualifies the parent. It's a statute that says if the court makes a finding that there's domestic violence, that parent is disqualified from having physical custody, not even just primary, but any physical custody. There is a rebuttable presumption in the statute that some of the judges use to overcome the presumption. Usually, I have to say it happens when it's old. So, like, if it's a 15 or 20-year-old incident, usually they'll say, well, it's in the best interest of the child. It's an old event. And they'll oftentimes use it against the other parent. They'll say, well, if it was so bad, why'd you stay? And of course, this just turns into an argument in court. But it is relevant. The weight of it may be weaker, but it's relevant. And if a judge, by the way, when judges throw cases out because of lack of change of circumstances, those are one of the easiest ones to get reversed because there's no findings or there's findings only made on the change. So if there's cases where they summarily deny and cases where they invoke change of circumstances are much more sensitive to being overturned. Much more sensitive. Because
All right.
anytime there's a summary denial, there was no hearing at all. So you don't even have to argue evidence. The
Yeah.
wind is in your sails to get it overturned. It's pure allegation. It's pure law. All you have to say is I alleged enough to get a modification if true. And then with res
Yeah.
judicata, they can get you on that, but it's still a much easier to get overturned once you actually go to trial and you have your day in court. That's when it's real tough to fix in family court because it's just a
Okay.
litany of findings. and those are
Okay.
all, they get deference on all of them unless there's clear error. But let's keep going. The viewers are blowing up over
Uh,
here. I don't know how your side looks,
Okay.
but there's,
Yeah, there's a lot of stuff happening on the chat.
well, people like
Uh,
when there's some kind of system or some kind of definition to what they're going through. They're going through all these stressful moments, and they feel like they don't know which way's up, and they feel like
yeah,
everyone is just doing whatever they want to do. And so I
that's true.
explained that there is stuff there that controls them somewhat, and they get excited to know that the judge isn't super powerful. They're powerful, but they have limits to what they can do. It excites people.
Yeah,
So,
totally. It should. I mean, it's, I think like the way that your mind thinks, Alex, and the success that you've had
mhm,
really gives another perspective. I mean, it's a different way of looking at these cases than just having your evidence and being prepared for court.
mhm,
It's what are you going to do to position yourself to appeal your case if you need to. I
mhm.
mean, that's the way it seems like you approached your
Exactly. I
cases.
had to. It was out of necessity that I did this. I saw a
Yeah,
problem. My son was suffering abuse. The court wasn't doing anything about it. So the next logical step for me was, how do I overpower the court? How do I force them to do what's in his best interest? It sounds really ugly, but that's what I decided to do. And it started working because I started to get decisions overturned left and right. So
yeah.
it's crazy.
Well, it is crazy, and and I often tell people, and I'm sure you do too, because you went through this
Hmm.
yourself. I mean, just because you lose a battle doesn't mean the war has been
Right.
lost, right?
That's why I did My Docket series. The first half of it is me losing. Losing, losing,
Yeah.
losing the whole time. And then I start to figure it out. And then towards the latter half, it's just nonstop winning. But
Yeah.
it's crazy. It's like, go ahead. You can keep going. I'm looking through some of these comments. A lot of
That's
people
okay.
appreciate both of us right now.
Oh, well, that's good. And Dwayne is saying that you're so smart, he makes your head hurt.
You know,
And
I learned a little bit at a time. People get overwhelmed by me, but it took 8 years, and each week I learned one thing. This was one thing, and then it started to connect. It wasn't like I just knew it all in the beginning. It wasn't like I figured it all out by going to a class or something. Just each time I learned one thing that was new, and now it's a lot of stuff, and so it sounds intimidating because it's so much stuff. But it was all at different times that I figured all this stuff out, and I figured out how to connect it, and it takes forever.
it does, it does. I mean, it really does.
Hmm.
And things are really kind of just, some things just sink in for me now. And I graduated from law school in 1995. I'm like, oh,
Hmm.
that's what he was talking about. I mean, it's crazy.
Hmm.
It's almost impossible to absorb it all at once. And a lot of times, in my experience, you only learn by doing.
Hmm.
Sometimes you only learn by
Yep.
losing, getting your butt kicked, or making mistakes. And
Hmm.
I still, I'm a pretty darn good lawyer, but I still sometimes get my butt handed to me. I mean, I do, but I learned something for the next client.
Yeah.
So Heather Zapata, she's an MBA that's on here. She wants to know what de novo review is. So can you talk a little bit about
So
that?
there's two types of review on appeal. One is deferential review and one is de novo review. So deferential review is where the appellate court, and by the way, it's not just one judge, it's usually a panel. So in Nevada, we have a 3-person court of appeals and a 7-person Supreme Court. The appellate court with deferential review will defer to the judge, to the family judge. Let's just say family court right now. They'll defer to the family judge's findings. They'll say, we don't really know if this is true. We're just going to trust you. So let's say there's 7 different witnesses, and 2 of them were on your side and 5 of them were for your opponent's side, and the family judge went ahead and believed the 2 over the 5. A lot of people don't like that. They think that's messed up, something's wrong. The Supreme Court gives deferential review to findings of fact. So they're just going to say, we just trust the judge. They must have heard something. There must have been a tone of voice, maybe somebody just sounded more convincing. We're not going to mess with that. That's deferential review. De novo review, that's a really good one. That's where the Supreme Court or the Court of Appeals says, we don't care what you were thinking. This is what we're thinking. They completely ignore the lower court's analysis, and they think this is how this law works. Period. Uh-oh, that doesn't match. Reversed. That's de novo
Yeah.
review's the best because you don't have to worry about them trying to figure out the thought process of the family court judge or how they got there or what they were thinking, right and wrong. No, they just look at that fresh eyes, and they decide how that should work. And if it doesn't match up and it's not a harmless error, watch my video on the topic harmless error to know what that is, then it'll overturn. So that's de novo review. I think it means anew or something like that in Latin.
Yeah.
And they
De novo. No. Yeah.
in Nevada they apply de novo to questions of law, and they apply differential to questions of fact.
So there you go.
Mm-hmm.
Hopefully that helped, Heather. That's like it's a tenacious warrior says you went to Rain Man mode right there,
Well,
Alex. That's a
defining
compliment.
it as much as I can, because I have the benefit of not being an attorney, so I can remember how things clicked with me as a layman, and so I'll explain it exactly the way that I learned it, and hope that it works for other people. And sometimes it does, and sometimes it doesn't. But it's one of the things I tell people is go into court with as many legal arguments that are don't just waste people's time. They should apply as you can, because those are the ones that you're going to get the best review on appeal. You know, when you're stuck in the factual area, sometimes there's nothing you can do, especially in family court. Family courts are heavy or fact heavy when they actually get to a trial, that is. But when they don't get there, you don't have to worry about that. If the judge is throwing your stuff out, saying there's no basis for a hearing here, well, you're going to have field day with that on appeal, because the whole thing is going to be reviewed de novo, because there's no facts. So
all right, that's good.
yeah.
So I have a case that I'm getting ready to take, and I have a feeling that's what's going to happen. So Alex,
Practice with those. Those are the best ones to practice with.
Yeah, I may have you on speed dial for that one.
There's one appeal where the attorney was upset that I couldn't prove something. He said he's relying on hearsay. I'm like, what are you talking about? There was no hearing. There's no hearsay.
Oh,
there's no hearing, man.
Exactly.
All I have to
That's
do
funny.
is accuse you, and that's good enough. You know, you're arguing that you should get a hearing. You're not arguing that you should win it. So it's everything. Your whole brain will change once you learn how appeals work. You're gonna come out feeling like Superwoman, like you can.
Oh, that's
Yeah.
I hope so.
Mm-hmm.
I hope so. I get out. I'm an old dog. I don't know how many new tricks I can learn.
I feel like it's easier too. It's less stressful because it's a straight road. So with family law, like, you never know what's going to happen in a family case. It can go sideways quick. But appeals just follow the same road every time. Opening brief, answering brief, reply brief, decision. That's it. You know where it's going to go. There's some extra stuff here, but it's very little.
Did you do oral arguments when you did your appeals?
Never. I don't think they would let me. But I want all of mine in writing, which is easier. It's less stress. They just mail you the order.
Yeah. I've seen panels, so I have to do continuing legal education to keep my license active, and they always have a panel of this appeals judges at this program I go to every year. And the appeals judges, well, on one hand, they say, listen, going into arguments, we have our opinion, a draft form. Like, we almost always know what we're going to do, but we want you to go in and still, have an oral argument. We like oral arguments because not very many people do them. It makes no sense to me. And I did one once. It was the most terrifying thing I've ever done in my life.
Were you before 3 of them, or were you before 7?
I feel like it was 3. Okay. Yeah.
There's this one hearing we got on our Nevada judges was in bank, which is full bench for the viewers, all 7 justices. And I remember this iconic moment where the judge on the far left asks him a question, the lawyer goes and talks to that judge, and then the one on the far right asks him something, and he practically whirls like a top to a judge from Judge 1 on the far left to Judge 7 on the far right. You could see the physical, like
really? Oh my gosh.
It's gotta be. He took a full battery of questions. It was a judicial discipline case. It was fascinating for a lot of people because those are so rare. And they overturned it. The Commission on Judicial Discipline imposed a public reprimand, and the Supreme Court heard it en banc and reversed it, it was a big deal here.
Oh my gosh.
Yeah, that judge got away.
Really?
I think that it makes sense. I agree with the ruling. There were issues. She was ousted in an election, so she ended up, the wrath of the public still took her off the bench. But I think that the decision of the Supreme Court makes sense as to why they overturned it. So.
Okay. Yeah. So are you still on the disciplinary committee?
Yeah, I have one coming up in like 3 weeks. I have one more. Yeah, those are it's really a privilege to be on those. I'm glad that they let me do those.
So are you doing those via video, or how are those working now?
The last one, I think I did 1 or 2, they were video. Yeah.
Yeah. Okay. I unfortunately, I say unfortunately now, I was a witness this is a little different. I don't know if you do this, but it
Mm-hmm.
was in front of the Committee on Character and Fitness,
Mm.
and for a former employee who I fired for dishonesty, um, went to law school and decided to become a lawyer. And of course, so they sent me a little form saying, do you think this person's honest? And I said no. And I had to go to the hearing
Mm-hmm.
and testify. Do you do anything like that as part of what you do? Is that totally different?
That sounds like that would just be lumped into the disciplinary process here. They don't. I don't know if you have two separate. We just have the disciplinary process, and I think they just do like resignations, which isn't even a hearing. So like you can resign voluntarily because your disability status or something, or you're just done because of your age and you want to retire. And then everything else, if there's some kind of problem, it goes into disciplinary. And then those are
Oh,
the ones that I'm on. So we can suspend, we can disbar, we can fine, we can send them to diversions, we can. It's pretty crazy. There's two parts. There's the formal hearing. I haven't done one of those yet. And then there's the screening panel. Well, actually, I've done some formal hearings, but it's where it's not adversarial. Like, there's a plea, it's been entered, and both sides agree, and we have to decide what the sanction's going to be. So I haven't gotten to do like a full blown hearing where we take evidence and then we make a decision in the sense of the state bar wants one thing and the defendant wants another. But I have done where both sides have given us an agreement and we read through it and decide what to do. And I've done the screening panels, which is where we go through like 20 or so cases and we decide, we screen him. We'll dismiss or
oh,
we'll send him to a formal. We'll dismiss, send him to a formal. We decide which ones are going to go and which ones aren't.
okay. Interesting.
Mm,
That's very interesting.
yeah,
But I bet it's fun for you.
it's fun because I like being a part of the system. It's the one way that you can make a lot of change is when you're in it. The
That's
change from
true.
outside comes too, but it just takes more work. Change from inside's
Yeah.
quicker.
Yeah.
And each panel
That's all.
each panel has to have a lay member, and a lot of times they appreciate me. They'll say, hey, we like to let the layperson speak first. We really appreciate you being here. These panels don't work without you. So the other two members are attorneys for any of the viewers wondering. So they're three-person, one layperson, two attorneys.
Cool. That's really awesome. Well, you are giving a lot in a lot of areas, Alex, so that's awesome.
Hmm. I loved
That's really
I loved having you on again. Are we about? Do you think we're about out of time?
I think we're out of
Hmm.
time. My daughter has a state report on the great state of Iowa
Okay.
due tomorrow.
Okay.
So, and she's doing distance learning, so I gotta, proofread it because I have a eagle eye for proofreading.
Okay.
So,
Okay.
eh, yeah.
Okay.
So it's great. It was great to do this coaster. It was super fun to talk about laws and
Hmm.
appeals and just life and whatnot. So let's do it again before another 7 months
Yeah,
passes.
we'll go. I'll keep you in mind, and we'll make sure. All right. Thank you so much